morning link.
It did. Yep, we got the good feedback from the witness machine that turns on with the microphone on. It's crazy loud. Let me just send one email. We can get started.
Judge,
Yes, sir.
may I have a brief moment with Mr. Smith?
DeAndre Smith.
No, Christavius.
The answer is, of course, I don't know. Is he on Anthony's iPad?
Is that okay? Yeah, that must be.
Okay, yeah, I'll put the two of you in a breakout room,
Yes.
and you two can talk. So give me a second. Breakout rooms. Mr. Smith, can you hear me?
Yes, sir.
Great. I'm going to move you and Mr. Richardson into a breakout room. So there may be something that pops up on your screen that you got to press to get on in there. Ricky Richardson, I've got a Kendra Richardson. Is that also you? I hope it is. All right. I'm going to move those into the room. And when you're in there, you can speak privately. Whoop. One of them's gone. They're both gone. Excellent. All right. What's going on, Mr. Brandt?
Hey, Your Honor, I just real quick, I have an announcement. Mr. Tinch has a case here, but he informed me that he cannot afford to retain me.
Okay, we're going to sit tight. I got to send one email and then we'll get started.
Thank you.
You bet. Okay, sorry for the delay. Good afternoon. It is plea and arraignment time. We've got a 13 position calendar that I will call once. I know there are a few bond hearings that folks are scheduled to have, and there may be a plea with Mr. Smith from wherever he is right now, Sumter County. But let's get through the calendar once, figure out who's here and who's not. And we'll go from there. Position one is DeAndre Smith, who I think is on just for a bond hearing. And Mr. Johnson may have that case. And I saw Mr. Johnson go into lockup. So he ought to have it. It was a Cladis special, which means it should not be Eric Johnson. Mr. Hand, you ready to go forward on bond in Mr. Smith's case?
Yes, Your Honor.
All right. Tanja, is Mr. Smith here? We don't know.
I don't believe so.
You think so? Okay. Tanja Barber, I also have down as a bond hearing. Did you see Ms. Barber back there?
I did, Judge, and that's actually going to be a plea today.
Ooh, all right. Happy Friday. And then a different Smith, James Smith, is on for a bond hearing. Mr. Whitenauer, how are you today?
I am good, Judge. That will be a plea today.
A plea. Excellent. Ms. Wood, also your case?
Yes, Judge.
All right. Eddie Brantley should be here.
Judge, this would actually be Miss Feely's case. I don't believe she's been able to contact or make contact with him.
Okay. Is Ms. Feely's situation improving, neutral? What do we know about how she's doing?
It is, Judge. I'm
Good.
just filling for you today.
Great. All right. Mr. Hand, any request on Mr. Brantley's case?
Yes, Judge, the state would request a bench warrant, Your Honor.
Let me look, just make sure it's not one of those, but the incident was really 6 years ago kind of thing. I think with this charge, it actually could not be 6 years ago. Or there's a different issue than bench warrant. See how recently. Yeah, so this was from 2 years ago. It took about a little more than 18 months to indict. Just looking at the two bond orders. Okay. I will issue a bench warrant, just looking a little bit at the history here. It sounds like Mr. Brantley has run into this issue before, not only the not showing up, but the theft charges. He was released to a program. So I don't know if that will assist in your office finding him. Maybe they'll have a last known address. He was released to the New Life Outreach Ministries in April, unfortunately, of last year. And that was the last, well, that can't be. Oh, and then he was in non-complex.
Judge, do you see this production order from non-complex in August?
Yeah, I'm looking at both. I'm seeing why. Johnson State Prison. And it was to be here in 3 weeks. So he may well be in Johnson State Prison, which would be why he's not here. So why don't we confirm that? If Mr. Brantley is not in state custody, then we'll reach out to you, Mr. Hand, to have your office do the bench warrant. If he is in state custody, then we will want to lock onto him there to make sure he comes back here.
Understood, Judge.
Thanks. Okay, so plea state custody, number 5. Brian Marshall. Are you Mr. Marshall? Oh, you're right. You're supposed to find a lawyer. And Mr. LaScala contacted us and said he should know by early next week whether you can actually make it work with him. Is that tough? Give me the update, please.
Yes, Your Honor. We're going here.
Podium's great.
So I spoke with Mr. Muscala. He had a family emergency
Okay.
in California, so he's dealing with that. He comes back next week, and then we're going to get everything together.
Okay. So it wasn't, and he didn't disclose the details, and it's not my business, but
okay.
it wasn't that he was saying, I need this much, and you were saying, I don't have quite that much. It's just he had a reason to be away from here, so you couldn't have that final handshake or signature or whatever it would be. You fully intend to hire Mr. LaScala.
Yes.
Okay. And he didn't say anything to the contrary. He just said, I can't file an entry yet because Mr. Marshall and I haven't connected.
That's correct.
And I let him know you still needed to be here, and you are here, which is good. And what we'll do, Mr. LaScala, when he officially becomes your attorney, may well be counseling you just to waive arraignment. So you don't have to come back again for this process of saying, I plead not guilty. And then the state can get discovery to him, meaning LaScala, and you guys are off and running. If he declines after talking with you to waive arraignment, and we're going to need to get you back here soon
I'll be here.
to do that, and I bet you will be here. Who from the state, this is an interesting combination of charges. Do we know who's handling it?
Yes, Your Honor. I'll be handling.
Oh, and you're handling it. Okay, Mr. Hand. All right. So Mr. Marshall, you are free to go. My staff will be reaching out to Mr. LaScala mid next week to say what's happening. If he files an entry and a waiver of arraignment, then we'll get a scheduling order out. Mr. Hand will be getting all sorts of paperwork to your lawyer, and we'll go from there.
Thank you.
Thanks for being here. He is. Okay, Mr. Johnson, Mr. Brantley is in Johnson State, number 4. So no bench warrant for him. We'll figure out how to get him here. There already is a production order that was done by Illinois Complex before they kicked the case over here. Derek Moore.
Judge, I filed a waiver. I spoke to him earlier this week. I believe it's an Odyssey.
I'm all for the waivers. Let's see.
Yes. It is in there.
Yep. Okay. So you filed an entry. There you are. It's no longer Javier Trejo. It is you, and you waived. So we'll do a scheduling order.
Thank you, Judge.
And Mr. Moore is out on bond. So you're in contact with him and he didn't need to be here. Okay. Baxter Ross. There's Mr. Ross.
Judge, if we could speak to him and come back to this one.
Sure. So Mr. Ross, this is Ms. Wood. She's going to want to talk to you. I'm going to get through calling this calendar in just a few minutes. Once I've done that, Ms. Wood will come talk to you. It may be she wants to exchange contact information. She may have an offer from the state for you to be thinking about. Who knows? Please don't leave until either Ms. Wood says it's okay to go or you and I have talked again. Okay. All right.
Judge, if I may note for the court, right now, my name is under number 7, but
Yes.
It will transfer to Mr. White.
Mr. Whitenauer. Okay. And he knows this.
Yes, he's aware. Judge.
All right. Mr. Johnson, good afternoon. We have a case of yours down for a bond hearing, a DeAndre Smith. Okay, we'll get to it in a sec. I knew you were back there and wanted you to know we mentioned the case. So we'll do that in just a few minutes. Sure. Position 8 is Ms. Benton. Waived arraignment. Oh, that's okay. Waived. And is it really Ms. Rockwell on it? Okay. Kenny Askew. So this was a direct indictment, says in big letters on my calendar. For something that happened in September of 2020. So 2-year-old case. I'm not convinced that a bench warrant is the way to manage this. That maybe there's a grand jury warrant, Mr. Hand, although I don't know that you may be transferring this one too. But I think that was the verb you used, was transfer. But the state's going to need to look into getting notice to Mr. Askew.
Yes, Your Honor. And it may be the bench warrant, the grand jury one.
Okay.
So I'll work on that, Your Honor.
Tolanta Tinch. Hey, okay. So let's talk about the situation. You can come up now. We had Richard Marks as his lawyer. I guess that didn't work out. And then he was trying to hire you, or?
He was trying to hire me, Your Honor. We got him a bond, and I think there was some confusion. We filed an entry. He cannot retain me going forward, so he's here.
Okay, got it. Mr. Tinch, have you and your lawyer had a discussion about finances going forward?
I just really can't afford them right
Oh, no, I believe you. I just want to make sure that the two of you have talked about it. It's not news to you what you're hearing your lawyer say right now. Okay. What I'm going to do then is ask Ms. Wood or her colleague to talk with you to see if you qualify for appointed counsel. If you do, then they can certainly help you. If you don't, and it maybe you fall in that awkward middle ground where maybe you can't afford this lawyer who wears fancy suits, maybe costs a little bit more, but maybe there's another lawyer you could afford, and we'll see how that plays out. But at a minimum, I'm going to ask Ms. Wood to talk with you because if her office can appropriately assist you, then you're going to get a great lawyer, and we don't need to wait around too much longer for you to sort that out because you've got some serious charges here. Okay. All right. So what you're going to want to do, let me get this case up here. So Mr. Brandt, you filed the entry of appearance that you filed was yesterday.
I know, Your Honor.
And then only.
I spoke to him on the phone and we had a different understanding. When he came to court, he informed me and I'm
Okay, got it. So you guys didn't have a meeting of the minds. You thought you did, hence your entry, and you now are hoping to undo the entry.
I did my job and tried to cover, and he was polite enough to be, and he was professional about it. He informed me when I walked in the door where he was, and I thought I'd let the court know.
Okay, no, I appreciate you doing that, and it is good to have all the right folks here. So you're free to go, Mr. Brandt, if you want to go. Ms. Wood needs to talk with Mr. Tinch. Mr. Tinch, you need to stay here so that you can have that financial discussion. And then either you're going to have a new lawyer, or I'm going to give you a deadline to find a lawyer that fits your financial situation. Okay. Good seeing you.
Thank you.
All right. Demetrius Benson.
Judge, he's in custody.
Oh, yes. Look at that. Okay. And you've talked with him.
I have, Judge.
Okay.
So a couple of things about this case.
Oh, he has two cases.
Actually, three. One is
Oop.
indicted.
Okay.
There is a motion that was signed by Judge Drake for, I think it might be the unindicted case, but I'm comfortable with him just coming to the door. I have spoken to him. I will do the waiver and everything, but I just want to let the court know there is a pending motion,
A motion
an ex parte motion.
in the CP case.
I believe it's the CP case. I saw it, a copy of it in one of the files.
Meaning one of your colleagues has asked for some work to be done.
Yes.
Okay, but it didn't flow through these two because you're brand new to them and maybe are just learning
Correct.
what your relationship is going to be like with Mr. Benson. But a colleague who maybe spent a little more time with him in CP land has said, hey, let's have this addressed.
And I think I have a question for the court. If that is, do I need to file motions on the indicted cases as well, or?
We would travel under the same outcome because if everything is okay for Mr. Benson, then he'd be okay here too. And if there's a finding on the CP side that he ought not to be moving forward with anything, it would carry over here as well. So I wouldn't want there to end up being two done. So I guess I'd hold off on that.
Okay.
Okay, and looking at the first case, I'm understanding more. So we should get Mr. Benson at the door for us to say what? We don't need to do it yet. What is it? You just want me to explain what's going on?
I think so. I spoke with him earlier, but it feels like he might want to see the judge.
Okay, we can do that. And do you mind if I let him know that there may be folks coming to talk to him and it's important that he chat with them so we can figure out how to move his cases along?
Please, because we did speak about that back there, but he would like to hear from you as well. I'm sure.
Sure. Any sense of what kind of charges are in the CP case?
I believe it's just a gun charge, Judge.
Just a gun charge. Is that where we are? Okay. All right. Understood. But it's not like the position 11.
Correct.
Okay.
It's possession of firearm,
Thank you.
Your Honor.
Okay. All right. Who handles a case like position 11 across these many different?
My case here.
That'd be yours? All right. Great. Good to see you. Let's get Mr. Benson, please, to the door. And while we're doing that, how about Ronald Richardson? Oh, he waived. That's right. You and I talked about that. Mr. West did that. Okay. Okay, so we've got one bond hearing, 2 pleas from this calendar, and we're going to do Mr. Smith first because he is on someone's borrowed iPad in a prison. So we'll do that. But let's handle Mr. Hey, Mr. Benson, how you doing? I'm Judge McBurney, and I have 2 cases with you. I know you've got a 3rd case that has not been indicted yet. I just want to let you know a little bit about how we're trying to move your cases along. I'm sure you're anxious to move them along. The lawyer who's helping you with that 3rd case, which will end up here, if it gets accused or indicted, anything other than dismissed, it'll come here. So we'll be working on it together. And you'll be working with Ms. Wood if and when it gets assigned here. But one of the lawyers who is helping you with that has had the good idea that there's some folks who should come to the jail to talk to you, just to ask you some questions about your past and how you're feeling and how you're processing all this. My encouragement to you, it's not an order because I can't order you to do it, but my encouragement is when those folks show up, and it may be one person, it might be a couple people, that you just engage with them authentically. So if they're asking you stuff, they know you've been charged with things. There's no secret. They're going to have already received police reports or indictments and all that. So they're not investigators with the state. They're just trying to make sure that you're in a good space. I don't mean the jail is a good space, but that you're thinking straight about what's going on. And they ought to be there fairly soon. We can't really do a whole lot with your cases until you have that conversation and those folks get back to me about their sense of how you're doing, how your physical and mental health is. So they're going to be talking to you about that, and then they'll let me know. And depending on what they have to say, we can get that 3rd case moved in with these 2 and figure out how to move your stuff forward. Okay?
I'm saying, would it be okay if I speak today or whatever? I mean, someone did speak basically the jail. She just said that, so I did speak with someone in that sequence. She never did say anything on the legal, she did say we have to have whatever. So she never did say we have a case because I don't feel this for the system or whatever, but she did speak. I was willing to stand trial that I comprehend or whatever is that 3rd. But
So you may have already had the conversation then. They need to write up a report?
she said that she would discharge the report.
Okay, so that may be what we're waiting on. You may have already had the conversation and then we're just waiting on the report. And once we get that, then Ms. Wood can come talk to you more about these 2 cases and we'll figure out whether it's trial, if that's what you want, or something short of trial where maybe.
I did. I did spend before we reached the police. I did service count.
Okay, well, and that's the kind of thing that Ms. Wood would share with me. But what we have to get clear first is whatever it is that those folks who talk to you or that person, they got to write that report. So I'm going to ask Ms. Wood to check with the organization that sent someone to see you to say, hey, did you already meet with Mr. Benson? Where's that report? How long do you think we need to wait? It'll be a week, it'll be a day, whatever it is. I just know I don't have it yet. And I need to get it before we can do anything more on your cases. We're not going to forget about you. I know you're anxious. The moment you said time served, I said, here's someone who wants these things to move along. So we'll do what we can to do that. All right. All right. Nice meeting you. So in terms of Mr. Benson, I guess we put it on an inquiry calendar for not too far out. I didn't make up too much. Are you able to reach out to Grady or Emery or whoever it is to say Benson on your list? And is that someone you've already talked to?
I have not, but I will, Judge, and I will go ahead and do the waiver and the substitution of counsel for these 2 cases.
Okay. So we'll waive. I don't think we'll do a scheduling order because I don't want to set this in motion of, oh, you got to file motions if it's going to take a hard turn to the right or the left to get Mr. Benson some other form of help. So we'll waive arraignment and then put this on an inquiry calendar 30-ish days out. If we get the report before then and it gives the green light to move forward, it may be that we shoot a scheduling order out and that will control and we pull it off an inquiry calendar.
Thank you, Judge.
Sure. Does that work for you, Ms. Charles and Mr. Hand?
Yes, Your Honor.
So this may be spread across like 19 prosecutors because Ms. Charles has position 11, position 12 is family violence, aggravated assault. Does that mean it's a Whitenauer case? Yes. Okay. And then the unindicted one, if indicted, will end up being Mr. Hands. This will be great that we'll never get a straight answer from the DA's office as to what's happening. All right. Mr. Nay, you can come on up. Here you go. Interesting list this time. A couple I had to look up. Like, who is this? But some of them, not so much. Have a good weekend. All right. So what we're going to do next is take I think, plea. Mr. Richardson, you still with us?
Yes, sir, I'm here.
Are you ready to move forward with a plea with Christavius Smith?
I am, Judge.
All right, Mr. Hand, you handling that?
Yes, Your Honor, and I assume I can do it for my best.
You sure can. Let me get Mr. Richardson spotlighted and Mr. Smith. Oh, Ms. Rockwell appeared virtually briefly. All right. Where did he go?
There's the orange outfit on, Judge.
No, I got him. It's just that Anthony's iPad doesn't jump out at me right away. Okay. Ms. Rivers, good afternoon. Are you ready?
Yes, I am. Good afternoon.
Good afternoon. So what we're going to do now is turn to case 22 SC 181297, State versus Christavius Smith. Mr. Smith, you able to hear me?
Yes, sir. I only can see Mr. Richardson and me. Is that how the screen's supposed to look?
Yeah, you should right now. I want to make sure you can see Mr. Richardson. If I need to, why don't I do this? Seeing me is very unimportant. I don't have a lot to do with it. Now you'll be able to see Mr. Hand as well. So that's the prosecutor. I think when you pled earlier with your other cases, it wasn't yet Mr. Hand, it was Ms. Charles, who's sitting next to him. You can see her shoulder there. There she is. You may recognize her. Mr. Hand is trying to replace Ms. Charles. She has been promoted, and Mr. Hand is very ably replacing her as we'll call the line prosecutor who handles most cases. Mr. Smith, it's perfectly appropriate for you to take a plea virtually like this, but I need you to tell me on the record that you waive your physical presence here in court, that you're okay appearing remotely.
Yes, sir.
Okay. The other important right that you're actually waiving a bunch of rights that Mr. Hand will cover, but one of them that you're waiving structurally is that Mr. Richardson is appearing on a screen there with that fancy blue paint in the background. He is not with you. He is somewhere else. Do you waive your right to have Mr. Richardson by your side for this plea?
No, I don't waive him.
Well, I didn't ask it well. Mr. Richardson will be present for the entire plea.
Oh, I'm okay. I'm sorry, I didn't understand. I'm okay with it.
That's okay. I didn't ask it well. You're okay with the fact that Mr. Richardson is in wherever blue room he's in, he's not with you. You're all right with that? Yes? Okay, good. Importantly, if you need to speak with him privately, we can do it. We've already done it once today. I'll just drop you two back in that breakout room. And then that is a private chamber. Whatever you say or do, only Mr. Richardson can see and hear. So please let me know if you need to have a private communication with him, okay?
Yes, sir.
Excellent. Mr. Hand, when you are ready.
Yes, Your Honor. And Your Honor, as a preliminary matter, the victim, Ms. Leslie Garcia, is on as well. I'm not sure if you want me to get through it, and then I know she wants to make a statement to the court.
Sure, and then she has an absolute right to do that. When you're done with the part of your presentation that you want to cover first, you let me know when it's time for victim impact, and then Ms. Garcia can speak, and you may have a little more you want to do. But before I turn to Mr. Richardson, I'll want to hear from Ms. Garcia.
Got it, Judge. Thank you. All right, Mr. Smith, if you can for me, raise your right hand so that I can see it in the screen. Perfect. Do you swear or affirm that the testimony that you shall give today regarding the matter currently before the court is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can lower your hand for me. Are you currently at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there any medicine that you would normally take today that you have not been given or taken yourself?
No, sir.
How old are you, Mr. Smith?
25.
And how far have you gone in school?
11th grade.
Can you read, write, and understand the English language?
Yes, sir.
And do you understand that you have been charged in indictment 22 SC 181297 with 2 charges? First being burglary, smash and grab, and then criminal damage to property in the 2nd degree.
Yes, sir.
Do you understand that you have the right to plead guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent or not enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the charges and facts and circumstances in today's case?
Yes.
Would you like more time to speak with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes, sir.
At this time, Attorney Richardson, do you waive a formal reading of the indictment for purposes of today's plea?
I do. The indictment has been read to him.
And do you waive any and all defects in the indictment for purposes of today's plea?
Yes, sir.
Okay. Mr. Smith, do you understand that the minimum and maximum sentence for each charge are as follows? For the burglary, smash and grab, between 2 and 20 years imprisonment. And for the criminal damage to property in the 2nd degree, 1 and 5 years imprisonment.
Yes, sir.
Do you understand that you are entering a non-negotiated plea today and that the state may recommend a sentence to the court even without you having agreed in advance to that sentence?
Yes, sir.
Are you aware that the state's offer is 20 years total to serve 6 years?
Say it again.
20 years total to serve 6 years, which would leave a balance of 14 years of probation.
Yes, sir.
Have you discussed?
That is their recommendation, Mr. Smith, to the
That-
court. That is their recommendation to the court.
Okay.
Right, just so you're clear, Mr. Smith, and I'm confident Mr. Richardson has explained this. Mr. Hand is going to advocate for 20 to serve 6. Mr. Richardson, because it's non-negotiated, is going to argue for something less than that. It may be a 20, but it won't be a 6. It'll be something less than 6. And I'll listen to both sides. I'll figure out what it is I'm going to do. And if I sentence you to something that is more than what Mr. Richardson asked for, you and Mr. Richardson can have a private discussion about whether you want to stick with that anyway. And you may say, you know what, you gave your best shot, Mr. Richardson. I want this behind me. I'm going to go with what the judge says. But if you don't want to, especially if what I say is, man, I remember you, and here's this case, and I heard from Ms. Garcia, I'm sentencing you to 20 years in prison. You can say, whoa, no, thank you. I'm going to go to trial instead. So I just want to make sure you understand there's a little flexibility in this process. I'll hear from Mr. Richardson. I'll let you know what I'm going to do. And if what I do is materially more than what Mr. Richardson asked for, then you'll be able to think about whether you want to step back from this and go to trial. Okay?
Yes, sir.
All right.
All right, Mr. Smith, have you discussed this offer with your attorney?
Yes.
And do you understand that the court may impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, sir.
And do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the court enters the sentence?
Yes, sir.
Do you understand that it is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Okay. Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering the guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation today of any kind, you cannot violate any criminal laws of any governmental unit, that being municipal, county, state, or federal laws?
Yes, sir.
Do you understand that if you are on probation, you must follow all of the special conditions of that probation?
Yes, sir.
Do you understand that if you fail to follow all of these special conditions of your probation, then you will be subject to the revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen, Mr. Smith?
Yes, sir.
And do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm in the future?
Yes, sir.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes, sir.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
And do you understand that by pleading guilty, you are giving up the following rights? Those are the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Say it again.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of burglary, smash and grab, and criminal damage to property in the second degree in indictment 22 SC 181297?
Guilty.
Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Is this guilty plea, do you understand that you have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of this guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
And do you understand that for a felony, you only have 4 years from today to file a habeas corpus petition?
Yes, sir.
Okay. Your Honor, at this time, the state will give a factual basis for the plea.
Okay, before you do that, I have a procedural question. In the docket for this case, and I was just looking at Mr. Smith's 3 other cases that he pled out to when Ms. Charles was handling all this. But in this case, there is a recidivist notice that was fairly recently filed. It's less than a month old. Are you leaving that in place? In other words, your recommendation of 20 to serve 6 is a recidivist sentence, or is part of the negotiation that you're withdrawing the recidivist notice?
It's a part of the recommendation, Your Honor.
Okay, so you're, and Mr. Richardson doesn't get to undo that part of it. So the sentence I impose will be a recidivist sentence. It'll be pursuant to the recidivist notice that you filed.
Yes, Your Honor. That's the request of the state.
Okay. Well, it's a directive of the state because you get to impose that. As I read the recidivist notice, Mr. Smith is an A and C, so that number 1, whatever statute he's pleading to that has the longest sentence, that's the first number I have to give, hence the 20.
It's, Your Honor, it's the state's understanding that it's only A.
Only A.
Yes, Your Honor.
Okay. And
The first conviction was a first offender that was not revoked. And however, it was listed for aggravation purposes, not for recidivist.
so the theft by receipt, I'm looking at the recidivist notice, there are 4.
Yes, Your Honor. And the last
arguably, the last one is one of the ones that Ms. Charles did.
Yes, Your
Okay.
Honor.
So that theft by receiving from the dates can't be quite right on this, or the indictment number is wrong. That's a first offender.
Yes, Your Honor.
Amphetamines, plain old felony. Marijuana, plain old felony. Obviously, this gun case is a felony. So you believe that he is a 3 felony?
I believe he's a 1. I believe he's only section A, because the only ones that would count for recidivism would be the second felony and the third felony.
Oh, because the fourth is too recent.
Yes, Your Honor.
It
did
occurred
occur.
after this alleged conduct.
Yes, Your Honor.
Okay, so he's got two priors, and so effectively two priors, which means we have to start with a 20.
Yes, Your Honor.
But whatever years to serve are parolable.
Yes.
Okay.
Yes, Your Honor. That's
That
safe
was
to understand.
that was tortured on my part.
And my part in telling you that up front. So
No, that's
I apologize
okay.
about that.
Mr. Richardson must have dropped off briefly. He's back. Hey, Mr.
Yeah.
Richardson, can you hear us?
Can you hear me now?
Yeah.
Yeah, my screen froze and I'm on my phone now.
Okay.
It's still frozen. Judge, I think the last thing I heard, and I hate that, was that Mr. Hand filed a recidivist notice within the last month or so.
Right. So I'll spare you a lot of pain because I was trying to figure it out. Mr. Hand represents that your client is only an A recidivist. And so the sentence that I impose, regardless of the recommendations, has to start with a 20. But whatever period of incarceration, if any, that I impose is parolable. That is what Mr. Hand is representing, because the first conviction in the notice actually was first offender. The fourth conviction in the notice is a conviction that occurred after this conduct. It was the case you had with Ms. Charles that resulted in a felony. So there are only two felonies that would count, which would make your client an A, which just means that I have to sentence to the max, but everything is parolable. Do you agree with that analysis or disagree?
Well, I agree with the analysis, but I guess I kind of don't understand. When we were here, I believe in June, and we tendered the plea, I would never have tendered that plea knowing that the state was going to come back, kind of loop around and file a recidivist to maximize his sentence as a kind of a tough mechanism. We tendered those pleas. We would have tendered them all together and asked the court to enjoin all of them. So the fact that he receives maximum sentence, I don't know if it's fair play or exactly what it is I understand the analysis, but I guess I don't appreciate.
Well, I don't know the dynamic behind it, but I want to be clear. None of the pleas that your client took in June with Ms. Charles are being used in any way to trigger it. So it's a amphetamine conviction from before, a marijuana conviction from before. It's not that by breaking these up into two, your client is in a materially worse position.
Right.
So I don't know what the negotiations were before, but Mr. Hand has made clear that the recidivist notice remains in effect. And so the long conversation we had when your screen froze was, I was looking at it, it says 4 convictions. Doesn't that then mean no parole? And then he helped me understand, no, because the first conviction isn't one, and the fourth conviction flowed from your representation, and so there are only 2.
Okay.
All right. Anyway, we digress. You'll be able to address that more when I hear from you. Factual basis, please.
Yes, Your Honor. And Your Honor, I also have certified copies of those if you need to.
Okay.
I have physical copies, but I know Mr. Richardson is virtual. Your Honor, were this to proceed to trial, the state would be able to prove that on December 31st, 2021, around 5:30 a.m., Sandy Springs police officers responded to a commercial burglary at 220 Sandy Springs Circle, which is in Fulton County. This is the address of a business called Alexis Suitcase, which is a retail consignment shop in Sandy Springs, owned by Ms. Leslie Garcia and Alejandra Garcia. The store sells high-end brands like Louis Vuitton, Chanel, and other brands. At the time, officers observed that the business showed a forced entry. There was also an alarm going off. They entered the premises. They also found a crowbar left at the scene as well, Your Honor. It appeared that those crowbars had been used to enter the business, and Ms. Garcia arrived on scene as well. Once there, she was able to share a store camera footage, which showed 6 individuals entering the store and taking several handbags and shoes while breaking multiple glass containers inside the store to get items inside. One of the individuals was not wearing a face mask and also wearing a hoodie with the writing Rick and Morty on the sleeve of that hoodie.
The old Rick and Morty hoodie. It's just all coming back to me now. All right.
Yes, Your Honor. Officers reviewed license plate reader cameras in the area just before the burglary occurred and identified two vehicles, one of which was a 2011 dark Buick LaCrosse, tag RZR6430, that was in the area about 4:47 a.m. With another car, which was a white Jeep. The Buick, though, and the second car both matched the descriptions of cars that were seen on the storefront cameras at the time of the robbery. It was used in the robbery to load the merchandise and then drive away. It's notable that the driver of the Buick LaCrosse exited the vehicle on the video wearing a Rick and Morty hoodie, as seen in the camera footage inside the store. The Buick's plates were covered during and after the robbery, but not just before the robbery, which is where the license plate reader picked up the vehicle. The officer ran the plates, revealing that the car was registered to a Mr. Christavius Jerome Smith. APD investigator Brent Davidson ran that name through the law enforcement database, got his name, phone number, sorry, not his name, his address and phone number, and also found other police reports involving theft and also a similar Buick car involved in those incidents as well. A search warrant was secured for the cell phone number that was found, as well as for the vehicle of Mr. Smith. January 12th, which is about 2 weeks later, the vehicle was spotted by Powder Springs police. They took the defendant into custody, as well as his cell phone, using those search warrants. For the phone, data about 2 weeks later came back showing that phone pinged inside of Sandy Springs at an address near Roswell Road in Sandy Springs, which is in the area of the store. Also, a search of the car using the search warrant led to a red expensive handbag being recovered that had an Alexa suitcase tag on it. There was also a search of the phone. There were photos inside the phone of different Alexa suitcase handbags with the tags on them, text messages with the exact item numbers that were used by the store as well. In the trunk of the vehicle, a Rick and Morty hoodie that matched the hoodie on the store video was recovered as well. Sorry, Your Honor, I just want to make sure I don't miss anything for the record. And so with these items, Your Honor, the defendant was taken into custody, and the state believes that and other evidence is enough to put the defendant at the location, having been involved with the events, also in concert with the other 5 individuals there. As a result, the victim, Ms. Garcia, had her security window bars damaged, security door bars damaged. There were pry guards as well that were damaged that cost her $2,500 for all of that equipment. The amount of merchandise taken was approximately $55,000. Using the sales price of those items, Your Honor, for that amount. This victim has, Ms. Garcia has been robbed 6 times prior to this. This is the 7th time. And so this particular event caused a massive loss to her. She has had to cover the losses of those handbags and shoes personally because she was fearful that she would lose her insurance because this was the 7th time that she had been robbed. Even now, it's caused her business to wind down. She's winding down the business, and she is also looking at debt as she's winding down the business. So at this time, Your Honor, the state would recommend the 20 years total, given the multiple felonies in the defendant's history, as well as the property damage and items, as well as the impact to the victim. We think that's a fair and reasonable sentence. Also, Ms. Garcia is on, and she may want to address the court as well.
Okay. So do you have a specific restitution amount? You bounced a couple figures around, and I know you were working on that. There was a request to maybe have this plea happen at another time. And my pushback was, we're going to take the plea, and it may be that we have a restitution hearing later. I'd love to wrap everything up at once if we can, but I'm not rushing you on the restitution front. Do you feel that it's sufficiently itemized and detailed, and that's not the hang up with the defense, or is the disagreement with the defense both dollars and time?
We don't have an exact amount, Your Honor. We're working with Ms. Garcia to figure out the out-of-pocket expenses and not just the sales price.
Understood. So you're looking to amend the sentence with a restitution amount once you've gathered what you want. It may be that you and Mr. Richardson can come to an agreement, and if you can't, we can have a hearing on that, and the result of that could amend the sentence.
Yes, Your Honor.
Okay, understood. Okay, Ms. Garcia?
Yes, Your Honor.
Good afternoon. Let me.
I would prefer not to be on camera if that's possible.
It is, you are not on camera. So
Okay.
just keep it the way you're doing it. And I'm happy to hear what you have to say.
I just wanted to elaborate on a couple of things. And forgive me, I am really trying hard to keep emotion out of this. This is my seventh. This would have been my seventh robbery. And just a correction is I had recently lost my insurance, just obtained new insurance right before this 12/31. And that insurance basically was going to pay me, we calculated about $7,000, and I was going to be canceled. So the choice was made not to file this on insurance because of those two facts. I did have to pay all these consigners out of pocket because I was trying to keep the business going. But as you can imagine, after coming out of COVID and everything else, that was the straw that broke the camel's back, so to speak.
Sure.
And the other things I want to point out is, this may be something that we can discuss later, but yes, restitution has been a point of contention, especially with me, with it looks like the defense saying they don't have the money or it's going to impose a hardship. You can understand my lack of sympathy when it comes to that, because there is proof that these handbags were unloaded. So obviously there's money somewhere from that. And the DA is correct in the fact that what I had to pay out was not what the sale price was, but I do have high commission rates. For example, on a higher end handbag, which is over $1,000, I have to pay out 75% of that. And anything that's over 3, we pay out 80%. So my cost, and I have the documentation that I can show the exact dollar amount. And then they also took shoe boxes, whereas they might have only taken one shoe, but of course I cannot sell one shoe.
Right.
So that item is since lost. So in order for me to try to keep my business going, I was trying to pay out consigners, and it's just, it created a hardship, and now we've since closed. Another thing I'd like to point out is, I don't know if the video was entered into evidence, but just to show the savagery, I don't even know if that's the word, of them, how they broke into the store. It was just a very savage act. And I'm also a little concerned the fact that he has not bothered to even implicate the other people that were involved. I find that very upsetting that there are 5 other individuals that he knows the information and refuses to tell. I think that says a lot about him, and I think that should be taken into consideration when he's sentenced. Any other thing I wanted to mention? And I do take offense to the attorney's use of fair play. I don't feel like it's been fair to me. So I have a problem hearing a defense attorney over there saying that, bringing up the idea of fair play. maybe that's where my emotion is getting in, but I think he should receive the max. And I'll be honest with you, I would prefer him, if it's a choice between the max and restitution, I'd rather him get the max. But as the DA did say, I am facing some extensive debt by winding down the business, and some is related to these items I'm still having to pay out. So I think I'm entitled to some restitution, but I do not want it restitution where you pay a little bit here and a little bit there, because I don't trust that I will ever see it. So I think there needs to be a good faith estimate to come up with a lump sum amount. And only then will I have any type of change of heart when it comes to what I feel is the fair amount of sentence. I know I don't get to make that decision, Your Honor, but I do think I have some skin in this game. And that's all I have, unless you have any questions you want to ask me.
Well, first, thank you for sharing that. You do have skin in the game. You're the victim in this case. And this is not a situation where, you know what, they broke in, they didn't take anything. Let's move on. It clearly was much more significant than that. Tell me, when you say this was your 7th robbery, robbery to me is someone walks in your store with a gun and takes things. Burglary is when someone takes things from your store when no one's there. Both are bad, both are financially difficult, both are a violation of your space, your privacy, etc. I'm just trying to understand what kind of business you were running. Did you have robberies where while you were in the store, people came in and pulled a gun on you, or they were like this case?
Your Honor, well, I'll definitely give you that detail. To me, both are equally bad.
So
And,
we don't need to debate that. That's not my question. I'm trying to understand what was going on.
Okay, I had 5 that were in the late hours. And I'll give you a little background on one. One we had was City of Atlanta. We had enough evidence to place 2 suspects at the location with video camera, with the license plate information, with enough that they felt strongly to go to a judge. Now, I don't know who the judge was. The judge would not grant a warrant. So that's one case. 2 times we were robbed during store hours, where my girls were roughed up each time. No gun was produced, but they were pushed and shoved and very fearful. So you're correct in that there was no gun involved, but there was some what quote unquote violence, I thought.
Sure. And my point wasn't so much the gun as it was the taking from a person, as in your store was open, someone came in and took stuff, versus your store wasn't open. And I'm not saying one is better or worse. I'm just trying to understand. You said 7 robberies, and I just wanted to understand what you were describing. But I appreciate you, one, being here. Too often victims don't take time out of their lives because they have other things going on to give voice to the other side of the equation. I've heard a lot about Mr. Smith through his lawyer and others who care about him. And it's important that I learn about the defendant. It is no less important that I understand the impact that the defendant's actions had on the community, on an individual, on a business, on your employees, et cetera. So I appreciate you sharing that. I understand the continuing emotion. I also understand your perspective that you'd prefer time over money, and that is a human reaction. So I don't know that you're going to get a restitution structured the way that you have described it, because sometimes the reality is an offender, when he or she is released, is not in a position to make any substantive payments right away. But we'll work through that as we can.
Okay.
But I just want to reiterate that it's very important that you stayed involved, and I appreciate you sharing what you did.
Thank you. Appreciate it, Your Honor.
You're welcome. Ms. Tucson, good afternoon.
Good afternoon.
I have information about Mr. Smith's recent convictions because those pleas were in front of me, And then I saw on the state's recidivist notice that there were 3 older cases, one of which is supposedly a first offender. Did you have anything else in your review?
Just the one that recently ended, the 17 SC 153224,
Okay, and that was for what?
possession with intent to distribute cocaine, possession of a firearm, convicted felon, possession of marijuana with intent to distribute.
Okay.
That was not the first offender case. And
No.
then the other case was 17 SC 149401, similar charges.
Yep. Okay. I've got those on the list. Excellent. Thank you so much.
No problem.
So, Mr. Richardson, you've disappeared again. Are you able to speak?
Yeah, something's going on with my Wi-Fi, but Judge, I see that Mr. Smith kind of shook his head. I'm not sure. I don't have any information on those 17 cases. I want to make sure that he is not in disagreement that that is him. And Mr. Smith, without divulging any facts, those 17 cases that involved the drugs, was your shaking of your head an indication that those were not your cases, or they are your cases?
Oh, I was acknowledged I was never on first offender for none of those cases. I had Judge Hicks at the time.
That was not, listen to my question.
Oh.
Is that your stepbrother or someone else using your name, or did you take a guilty plea to those charges?
Yeah, I had 5 years on probation for those 4 or 5 years.
That's all I was asking. So nothing further. I just his body language, Judge.
No, I understand. I noticed this. I mean, he was reacting to a number of things throughout the last few minutes, but it looks like there is a 17 SC case to which your client did enter a guilty plea, not as a first offender. The state's got these copies. It only takes one to get us into the recidivist field that Mr. Hand is putting us, and appropriately so. That's 100% the state's prerogative. And that's why the state's recommendation started with the 20 rather than a number less than that. So given that, what else do you want to add, Mr. Richardson?
Judge, just that Mr. Smith is the father of 2. He has a 2-year-old, has an 11-year-old. He is, I believe, engaged to be married. And I think the young lady is on the platform. She appeared in the court before. They have a janitorial cleaning service where they clean up office buildings as well as residential areas. She is in the process, or they're in the process of trying to get some type of transportation delivery company upon his release. Judge, I didn't mean to kind of factor myself into it, but Mr. Hand and I, that's another day, another dance. But with regard to the payment of restitution to Ms. Garcia, and I empathize and sympathize with her position, Mr. Smith indicates, and I think he said it before when we were in court before Your Honor, that he has a $5,000 tax refund coming to him. But because of his location, he's not able to sign whatever documentation to get that. He is certainly prepared to turn that amount over to the state on behalf of Ms. Garcia. Additionally, he has a vehicle that he is prepared to sell. Again, logistically, he has that difficulty. As I understand it, he is not scheduled to be released until February the 21st of this year, which will have him in custody for a full year. And so that money is available. I'm not sure what the car will sell for. There are no liens and encumbrances to it. So certainly $5,000. The significant other seems to believe somewhere between $5,000 and $7,000 is what the other car would sell for per CarMax. So he is willing, certainly as a special condition of probation, to turn over the $5,000 from the taxes, as well as whatever the proceeds are from the vehicle that he would sell. Beyond that, Judge, he was raised by his grandparents or his grandfather. There was some family difficulty apparently with his parents, so he was reared by his grandparents. He did complete the 11th grade at South Atlanta High School. He has one sister. Says his father, who he's estranged from, has several children, but he doesn't really know his other siblings. I think he's expressed remorse, Judge. By being here, he's accepting responsibility for his actions. We did look at the video. The face is not really clear. It is a case that is probably some physical evidence and some circumstantial evidence, I'll say. But Mr. Hannah and I have worked kind of in good faith. I wish I could tell Ms. Garcia that we had the full amount, the 2,500 and the other amount that she's out of. We don't have that, Judge. What we do is have a defendant who's remorseful. He's accepted responsibility. In June, he took pleas with the other prosecutor. He comes here today and accepts responsibility, Judge. The dynamics of turning over to other people is fraught with a lot of different things that we know in the legal profession. Certainly he put himself in that situation, but 5 other people might not look favorable upon him, and it could cause physical injury to both his family as well as him. And so he, that is, something he's not capable of doing, I don't think, right now. Certainly, if it was possible, I would have approached Mr. Han or Mrs. Willis and said, look, if you're interested in other 5 people, but that is another situation, Judge. The 20 years is a long time, obviously, to be supervised. He's been in custody for more than a year. What I would ask the court to do, since 20 is, I guess, statutory mandatory, is that the court would give him 20 years. Obviously, I would want 20 years to serve one and allow him to get out and pay Mrs. Garcia her money back as soon as possible, with a lump sum up front within, say, 60 days of being released, and put him on probation for the balance, what other terms and conditions. And with that, I would leave it in the court's hands in terms of fair and reasonable. He had ever been to prison, so this year has been substantial. I think it's made an impact on him. He's has a child that's, like I said, 2 years old, that for a better part of a year, he hasn't been able to see, touch her. And I think it has had an impact on he and his family, his significant other, and the child. So he is being punished, and certainly with 20 years probation, he'd have to walk a very, very fine line. If he didn't, obviously he'd come before the court and be subject to court revoking the entire 25 years, the criminal damage as well as the burglary charge. So, Judge, I won't. This is sometimes less is more. I'll leave it right there, Your Honor.
Okay. Well, I appreciate that. Mr. Smith, is there anything you want to add?
Yeah, I'm here taking responsibility for the action that caused. For my actions, I know I don't have the money up front to give her. She kind of have a problem by not having. She don't want to wait. She want her money up front, but it's like I can't give her money because I'm in my current situation. I'm incarcerated, so it's like I don't have no large amounts of money to give her, and so if I was free, I'm willing to, right hand to God, I'm willing to pay. I know what she's going through with her things, the money she has to been paying for out of her pocket for her business, but I'm willing to pay. I'm willing to sell my car. I'm willing to turn over my tax checks to her. I'm willing to, my fiance, we're trying to start our business back up with the cleaning. I haven't been there to help her with that, so that's slack. She was willing to take out a loan for me, so when I get out, that she's like, we could start this so you can make some nice delivering. So within like a year or so, actually pay. I forgot her name, the lady who owned the business. I'm willing to actually pay her for her. If not, I'm willing to be took back into custody for paying her back for the that I caused.
Okay. Well, I appreciate you sharing that, Mr. Smith. We don't do debtor prison anymore. Your inability to pay wouldn't be a reason to go back into custody. But I heard Ms. Garcia pretty clearly that while the financial hardship that the crime you were involved with caused her, her focus isn't, she'd love to get reimbursed, but that's not her focus here. I think what she's helped us all understand is that property crimes, which is what this was, there wasn't someone there at the time. Her employees weren't roughed up this time. No one had a gun put in their face this time. But these property crimes can be destructive to ways of life as well. And Ms. Garcia is having to cycle out of this line of work and do something different. So it does have a pretty big impact. Mr. Smith, I find there's a factual basis for your plea. I may view, assuming what Mr. Hand said could be proven at court, as a pretty strong case for the state, given what was in your car and the Rick and Morty hoodie and all that. But we're not there right now. I don't need to gauge how strong or not strong. I think it's sufficient that a jury could find you guilty of both counts. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. Is that a fair statement?
Yes, sir.
And knowing means that you understand all the things we've been talking about. Is that true also, or do you have any questions for me or for Mr. Richardson?
No, I understand, Your Honor.
Okay. I'm going to sentence you pursuant to the Probation Options Management Act, which means for the portion of your sentence that you're on probation, if you have a minor violation of probation, you and probation will work through that. But if it's major, you get arrested again for anything, something like that, that comes back to me and we'll work through what should happen with that. I'm not setting a restitution amount right now anyway, so it's not like you need to worry, hey, when am I going to sell this car? Ms. Garcia is going to continue to work with Mr. Hand when they believe they've solidified the proof of the restitution amount, because it's not just say so. Just so you understand, Mr. Smith, it's not Ms. Garcia saying, I think it was about $50,000. There needs to be documentation. Mr. Hand will share that with your lawyer. And if he thinks that that is sufficient proof, he's going to say the numbers are the numbers. They're big, but we got to deal with that. If he thinks that it maybe is speculative, as in, I think this is what was stolen was worth, then we're going to have a hearing and the state's going to need to convince me that the dollar amount should be up here rather than down low. So we'll get to a restitution number. We don't have that right now. Hold on one second. Got a little situation back in lockup. Okay, I'm back. So we're left with what to do. As I said, it was helpful to hear from Ms. Garcia, the impact that this had. The tough part for you, Mr. Smith, is that you're having to shoulder everything right now. And I share this not to get you to say, all right, here are the other guys. But let's assume for a minute restitution ends up being $60,000. You're the only one right now responsible for all that. If there were other defendants, then you start to divide that restitution across a number of sets of shoulders so that someone else could say, I'm going to sell my car, or, hey, I still have those shoes, or I'm the one who sold the shoes online after we stole them. And you could allocate restitution differently. But for now, thanks to your Rick and Morty hoodie and the tag on your Buick, you're the one responsible and liable for all of it. It's also necessary for me to keep in mind that you pled to a bunch of other stuff recently that was all sort of going on in your life. You had a rough 2021. I forgot to ask you, Mr. Richardson, you said your client's been in jail for more than a year, but this incident happened on December 31. So I may have misheard you or you misspoke.
No, Judge, once he's finished serving his time on February 21st, he will have served a full year.
Got it. Okay. That I did understand, but I don't mean to minimize the amount of time you've been in custody, Mr. Smith, but it can't have been a year yet because there you were on New Year's Eve breaking into a Lexus suitcase. Mr. Smith, because you are being treated as a recidivist, which is something that the state invokes, I have to sentence you. Your sentence has to start with the maximum number. So your sentence has to start with a 20. On count one, I am sentencing you to 20 years to serve 3. Those 3 will be followed by 7 years of probation, and the remaining 10 years will be suspended. Your sentence on count 2 is 3 years to serve. It will run concurrently with count 1. So it is a total sentence of 20 years, serve 3. You'll get credit for all the time you've been in, followed by 7 years probation, and then 10 years are suspended. So you will be supervised for 7 years. It's during that window that you'll be obligated to earn the money and provide the money in restitution, whatever that dollar amount ends up being. But I think that sentence reflects the seriousness of this offense, the seriousness of your criminal history when we weave in these recent pleas that you had. Appreciate that a couple of your cases are a little bit older and you seem to have had some downtime and things pick back up again in the last year or so. These are parolable offenses. So it's not 3 years to the door. It may well be that pardons and paroles determines that you have served a very, very significant portion of those 3 years as they calculate parole for a property crime like this. I don't make that decision, but Mr. Richardson can advise you on that. The sentence that I'm imposing is more than what your lawyer asked for. It is less than what the state asked for, but it is what I think reflects the situation we're in. Your ability to be a productive member of society, plug in with those businesses you want to plug into. I appreciate you had some plans to move forward. I appreciate equally that the things you did on December 31st of last year upset the plans Ms. Garcia had to move forward. And those two things are in tension. And the outcome of that is that I think you ought to be in custody a little while longer. But that sentence is more than what Mr. Richardson asked for. So what I'm going to do is move you and Mr. Richardson into a breakout room so you can talk about the wisdom of accepting this or saying no thank you, which you're perfectly free to do. And then what we'll do is have a trial and a jury will hear about what happened on December 31st, 2021. And after they hear about that, if they say guilty, then we'll do sentencing all over again. If they say not guilty, then you would have made the right decision to say, I don't want to take that sentence. So do you have any questions before I get you and Mr. Richardson together?
No, not right now, sir. Not right now, Your Honor.
All right, let me get you guys back in a breakout room. Okay. So I can't move hold on. Just give me a second. That'll do it. I'm not going to do it.
Judge, this is Miss Singley at Sumter County CI.
Yes, ma'am.
Are you done with offender Smith?
Almost. I need about 2 more minutes, but I'm having trouble. I want to move him into a breakout room and the iPad is stuck in a breakout room already and it's not letting me. Let's see if I can. I just got him out. All right. Mr. Smith's going to speak with his lawyer for about 2 minutes. They're going to come back with me and then we'll be done. Okay.
Yes, sir. Captain said we can give them 2 minutes.
Great. Thank you so much.
Yes, sir. Thank you.
So make it snappy. There we go. They're in. Ms. Tucson, we're not going to have time for you to talk with Mr. Smith after this because they're going to need to yank him or get that iPad back. So you can plug in with his lawyer. Assuming he accepts the plea, he's going to be in custody a while longer anyway. And then Mr. Johnson, we're going to do, assuming DeAndre Smith is okay. There was someone who was having a medical situation back there. I don't know if it was your client or someone else, but if DeAndre Smith is okay, we'll do that bond hearing. Ms. Wood, what did you find out about Mr. Tinch?
apologize, Judge. I went ahead. So it looks like Mr. Blake had already done a waiver, but I filed a substitution of counsel.
Great. So you'll be or your office will be representing Mr. Tinch,
Yes,
and there's a waiver so we can do a scheduling order.
And I also updated his address. Odyssey had the apartment number incorrect, so.
Okay, fantastic.
Anyway,
Thank you.
you're welcome.
Ms. Wood, can you advise who you think will be representing Mr. Tinch?
Yes, Miss Feely,
Feely, okay.
is that yours?
It is.
Okay.
Mr. Whitenauer, I have not ignored your request for that YouTube. I think the answer is yes. I just have, I'm not real technically savvy with YouTube, much to the chagrin of my kids.
No need to bother with it anymore. I'm sorry, I should have followed up with you and let you know that all has been resolved.
Oh, okay. All right. Excellent. Done. Uh-oh, bringing in the brass here. He's looking around. Ooh, good to see you.
I'm back, Judge. And he's-
Okay. And is Mr. Smith back too? Oh, I wonder if they took him away.
Hopefully not.
There's no Anthony's iPad on here. Tell me what.
He was accepting the plea, Judge.
Okay. So I'm gonna go ahead and do the paperwork. We're gonna need to reconnect anyway about restitution. And we'll get Mr. Smith in the mix there. And we may reach out to Sumter, wherever he is. But based on your representation, I'm comfortable signing the final disposition so that he can begin to, there he is. Hey, Mr. Smith, can you hear us?
I can hear y'all.
Great. Mr. Richardson just shared with me that you've decided to go forward with the plea. Is that correct?
Yes, sir.
Okay. We will reconnect with you about restitution if there's a dispute about that. If Mr. Richardson gets the paperwork and confers with you and there's no dispute, then we won't bug you again. But if there is, then we'll have a hearing about that and we'll get you patched in like we did today. Mr. Richardson, anything else on behalf of Mr. Smith?
Nothing, Your Honor.
All right, I appreciate your time. Ms. Garcia, I appreciate you taking time out of your life to share your perspective. And Mr. Hand, thanks for your work.
Thank you, Your Honor.
All right. And thank you, Sumter. You all can take your iPad back.
Okay, Judge, thank you.
Take your iPad back. All right. Are we able to get DeAndre Smith out? I don't know who is unavailable. Yes, ma'am. Oh, you were just sticking around to see how that went? All right. Mr. Hand did all right.
Sorry, I did excuse.
Yes, sir.
All right, thank you. Take care now.
Thank you, Mr. Richardson.
All right, Ms. Hand, I'll be in touch with you.
DeAndre. All right, Mr. Smith, you can take a seat at the table there. Mr. Johnson, when you're ready.
Oh, Your Honor.
Let me get us on the record and then we'll get going. Ms. Rivers, you still with us?
Yes, I am.
Great. So this is 21 SC 179330, State versus DeAndre Smith. Mr. Smith, you are now represented by Eric Johnson. There's been a transition in the conflict defender's office. Mr. Johnson is stepping up, and he is here to argue a bond motion on your behalf. So I'm going to hear from him about bond. I will hear from Mr. Hand, who is the prosecutor, and I'll let you know what we're going to do.
Good afternoon, Your Honor.
Good afternoon.
We are here today on a bond motion in case number 21 SC 179330, previously filed by attorney Mario Cladis, Your Honor, on behalf of Mr. DeAndre Smith. Mr. Smith stands before the court today, Your Honor, charged with armed robbery, aggravated assault, hijacking a motor vehicle, possession of a firearm during the commission of a crime, and willful obstruction. Mr. Smith is a 23-year-old lifetime Atlanta resident. He is the father of a 3-year-old child. His education level, he completed the 11th grade. Prior to his incarceration, he was employed at a warehousing job in Union City, Georgia. He does have an address of 228 Troy Street, Atlanta, Georgia, where he would be residing if he was provided an opportunity to be released. Your Honor, in this particular case, we'd just like to point out that my client has been in custody without bond since his arrest on September 18th, 2020. Taking that into consideration, Your Honor, given that the judicial emergency and the statewide judicial emergency ended on June 30th, 2021, that means at that point in time, the state had 90 days after the end of the judicial emergency to indict my client's case and give him a bond. His case was not indicted until October 8th of 21, which is more than 90 days after the time frame, the end of the judicial emergency in this case. And my client has languished in jail without bonds since then, Your Honor. I do not believe he has any prior felony convictions after speaking with him in this matter, Your Honor. So we do believe that he meets the Feretta factors for release in this particular case. He is presumed innocent of the charges in this particular matter, Your Honor. And we do believe that the court can impose any kind of restrictions necessary to keep him away from the incident location and any other individuals that may be named as victims or witnesses in this case. So that is not something that should preclude him getting a bond in this particular case. As I stated before, he is a lifetime Atlanta resident. He's 23 years old. He has ties to the community, multiple family, as well as his child that lives in the Atlanta area. So we do not believe that he is a significant risk to flee the court's jurisdiction in this case. Now, Your Honor, we'd just like to point out that while the crimes that my client is alleged in this matter are violent in nature, we do reiterate that he is presumed innocent of these particular charges. So that in and of itself, we do not believe the existence of these charges would make my client be designated as a threat to the community or possible a risk to significant danger to any person or property in the community. His lack of a extensive criminal history, the state may correct me. As you know, I've just been appointed to this case, so I did not have a full recitation of his criminal history, but I believe that he does not have any prior felony convictions. The state can correct me if that's the case. And given the fact that if it does find that he does not have any prior felony convictions, Your Honor, we do not believe that then he is a significant risk of committing any felony if he was released in this particular matter. And as previously stated, Your Honor, the court can impose any kind of conditions that they want to keep him away from any witnesses or victims in this case. And my client is definitely willing to adhere to those conditions. As such, Your Honor, we do believe my client is entitled to a reasonable bond in this case, based on the facts of this matter, his lack of criminal history, as well as the fact that he has not been given a bond after 90 days after the end of the judicial emergency in this case. And speaking with my client, I do believe that he would be based on his family's obligations and commitments, that they would possibly be able to make a bond in the amount of $30,000 to $35,000, Your Honor. So just wanted to put that out there, and we would ask that the court set a reasonable bond in that amount or lower with whatever conditions the court would be inclined to place on to secure my client's presence and the safety of the community. Thank you, Your Honor.
You're welcome. Couple questions. Where would Mr. Smith be living upon release if he was given a bond and he was able to post it?
228 Troy Street, Atlanta, Georgia, right?
Oh, so that Troy Street address remains open to him?
Yes, that's his mother's address.
Mom is there. Okay. Okay. I'm noticing that the co-defendant got a signature bond, not legal, but got a signature bond from another judge. And so is out on bond, had an ankle monitor. We've had a few hearings about modifying the bond. I guess it was to shift payment of the bond, the ankle monitor from Mr. Heinzman to the county. And so Mr. Heinzman, the co-defendant, is on bond with an ankle monitor that the county is paying for, just so that you understand how a similarly situated person finds himself.
We'll take one of those with a signature bond also.
Yeah, this judge is going to follow the law. Can't give him a signature bond, but it's just that it's a helpful fact. Mr. Hand, tell me about the state's perspective, keeping in mind what's been done. And I don't know that the state agreed with the bond that was set for Mr. Heinzman, but we've got co-defendant with a bond. Let me know your thoughts about this case and Mr. Smith.
Yes, Your Honor, I know that the state, at least right now, Your Honor, I wasn't present for that hearing, but not on the signature bond, and I hear that's not what you're doing, Your Honor. But the state would request
Put your microphone on, please.
Oh yeah, Miss Charles has a way of turning that thing off. Don't always leave it green.
Can you hear me now, Judge?
I can hear you.
Miss
Rivers.
whoever stated, Miss Rivers.
Yes.
Thank you. Your Honor, the state would be recommending a bond, but requested it be a high bond. We have spoken with the victim, Mr. Bleecker Daniels, who is not opposed to bond. However, he wants to note that this was a very dangerous incident. He had a gun pointed at him. The defendant, who's in the court right now, told him he would kill him multiple times if he didn't give him the car keys. He took the keys, left the incident location, and it took officers quite some time to locate the vehicle. And then they fled again. And then it took officers another couple hours to then locate the defendant and another person who were apprehended at that time. Firearms were located on them as well. I will note the defendant does have 8 cycles, Your Honor, but at least of one of those, it is a theft conviction. It's a misdemeanor theft conviction, but it is theft. So there's a history of theft. So speaking to the Ayala factor of danger to property and people in the community regarding the firearms that were used here, we would just request a high bond be issued. Also, the same conditions for the co-defendant, including a curfew, an ankle monitor, the co-defendant, I'm showing, got a pretrial level 3 supervision. We request some type of supervision along with the monitor, and no contact with the victim or the co-defendant, Mr. Kevin Heinzman.
Okay. And did Mr. Daniels know his alleged assailants, or
No, Your Honor.
how were they ultimately, they meaning Heinzman and Smith, connected to this?
So,
State's theory.
So, Your Honor, I'm not sure, other than their acquaintances. I don't believe they're related in any type of way, but they were both. So this is an incident where Mr. Daniels did food delivery and grocery delivery. He went to go deliver items. When he went to the door of the customer, 2 individuals were approaching his car. One had a gun, told him to give him the keys. That's the defendant here. The other person standing by the car is the co-defendant, Mr. Kevin Heinzman. They were both identified and arrested together when they were caught.
Got it. I noticed there's a motion to suppress ID. So either there was a show up or there was a photo. Okay.
Yes, Your Honor.
Got it. And they, Heinzman and Smith, were in Daniels's car when they were apprehended. Well, I guess they ran from the car.
Ran from the
Got
car.
it. Okay. Okay. I understand.
They were seen in the car. They got into an accident and then fled.
Yeah. They're connected to the car. Anything you want to add, Mr. Johnson, or you feel like you've covered it?
Well, yes, Your Honor, just briefly. Would just like to point out that based on the recitation of the facts of the state in this case, the 2 defendants, the 2 co-defendants in this matter would seem to be somewhat similarly situated with regards to their activities, as alleged activities in this particular case, Your Honor, so that we believe that given that their criminality in this case is somewhat similarly situated, that their bond should be somewhat as well. We understand that the court is not going to give him a signature bond, and actually cannot by law give him a signature bond. However, we would ask for a reasonable bond in this case, Your Honor, with the conditions as stated. And also would just like to point out, given the nature of the facts in this case, there may be potential issues at trial that come up with regards to identification and things of that nature. So the victim's feelings about this matter, while important, are not necessarily definitive of my client's guilt or anything of that nature, Your Honor. And so as such, we do believe that that particular factor does not weigh heavily against him being granted bond in this particular case in whatever reasonable manner. And as previously stated, we would definitely adhere to any conditions with regards to staying away from the victim. And as Mr. Hand stated, this was a random occurrence with a gentleman delivering food. My client has no knowledge of the home or actually where the other individual was coming from. And as such, Your Honor, we renew our request for a reasonable bond.
Okay.
Your Honor, I don't mean to get the last motion on, last word on someone else's motion, Judge. I'm
Except
sorry.
you're going to.
I just want to correct the record. Judge, I mean, so when the case was first charged, there were only 2 counts.
Correct.
Hijacking and the.
Technically, Mr. Heinzman is on no bond status for 3 of his 5 counts. I share that with the state. He is on no bond status with 3 of the 5 counts of his indictment, maybe 4 of the 5, because I think there was a misdemeanor and hijacking was the CP case. Maybe it was the obstruction, but either way. I
just wanted to state that the initial bond was, much higher for the hijacking count, which was the most serious, which was
right.
$20,000.
Right. Okay, I followed that. So I will set a bond for Mr. Smith. Mr. Smith, your bond is $20,000 for count 1. It is $5,000 for count 2. It is $20,000 for count 3. And then it is $2,500 for counts 4 and 5. That adds up to $50,000. It will be through the sheriff's 10% program, which means if your family or you put that money up, and you don't have to put up 50,000, you put up 10% of that, which is 5,000, they'll get virtually all of that money back when the case is resolved. You will be required to wear an ankle monitor, which will be paid for by the county. You will be required to reside at that Troy Street address, and you will initially have a curfew from 8 p.m. to 8 a.m. So you can be out during daylight hours. If you can document that you've got a job that is, I'm making it up, from 5 p.m. to midnight, we'll adjust the curfew so you can have that job. But for now, if you're working, it's got to be during daylight hours. No contact with Mr. Heinzman. Definitely no contact with Bleecker Daniels. That's the alleged victim in this case. And I don't know if there was anything else.
There's the pretrial supervision.
Oh, right. And you'd be subject to pretrial supervision level 3 to start with. That's the most intense level. If things go well, Mr. Johnson can always ask to have that ratcheted down. And sometimes pretrial services will ratchet it down if things are going well. I think I covered all that. Anything else you'd want to see in terms of conditions, Mr. Hand?
No, Your Honor.
Mr. Johnson, any questions about Mr. Smith's bond?
No, Your Honor.
Okay, thank you.
I guess my next only question would be, and I guess that'd be more so for Ms. Nelson. The court noted that there had already been a motion to suppress ID filed. I was wondering, had that been scheduled as of yet?
It has.
It's in January, I believe.
January 3rd. There was a date. The calendar hasn't been published, but you can, January 6th.
I'll get it.
Yeah, 1/6. You'll get a calendar. You have a motion to suppress statement and ID that your predecessor has filed on your behalf.
Gotcha.
All right.
Thank you.
Ms. Wood, do you want to do Ms. Barber first or Mr. Smith first?
Both are signed up, Judge, whatever is easiest for the sheriff's office. Oh, right there, put that one wall right there. Put that one wall right there. Yeah. Oh, do I have an office? Yeah. Officer. That was officer. Who we need him?
Barber?
Just the barber.
Ms. Barber.
Miss Barber. All right, Frank. Thank you. Oh, yeah, that's, if, yeah, we could have her.
Sure.
Do you think you might? You'll see for me. I'll look again. So sometimes they don't show up until the book out process. But we'll look, okay?
All right. Well, you ready, Ms. Wood?
Yes, Judge.
Okay. This is position 2, 22 SC 181087, State versus Ms. Barber. Good afternoon, Ms. Barber.
How you doing?
Hey, Ms. Barber, Ms. Wood tells me you're prepared to enter a plea in your case. Is that correct?
Yes.
Yes. Great. You're gonna need to speak up. So our court reporter, who is invisible to you, but she is listening, she's gonna hear things through that microphone. Mr. Han, the prosecutor, is gonna put you under oath and then we'll get started, okay?
Yes.
Ms. Barber, if you can hear me, raise your right hand so I can see it. All right. Do you swear or affirm that the testimony that you shall give the court in the matter before the court today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can lower your hands for me. Please state your true, correct, and legal name for the court.
Sandra Constantine Barber.
And are you at this time taking or under the influence of any alcohol or medicine?
No.
Or drugs? Okay. Is there any medicine that you would normally take that you have not taken today?
No.
How old are you, Ms. Barber?
52.
I'm sorry?
52.
Okay. And how far have you gone in school?
11th grade.
Can you read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the following offenses today in indictment 22 SC 181087? Those are count 1, aggravated assault, family violence, count 2, aggravated battery, and count 3, battery, family violence, a misdemeanor. Okay.
It's okay. Someone back there. Just hold on 1 second, Ms. Barber. We're gonna let these gentlemen come through. Mr. Johnson. Hey, Mr. Johnson, you got an email from Ms. Nelson. Make sure to check it. Okay, let's keep going.
Ms. Barber, do you understand that you have the right to plead guilty or not guilty to these charges?
Yes.
And do you understand that if you plead not guilty or remain silent and refuse to enter a plea at all, that the state is required to prove these charges against you?
Yes.
Have you had an opportunity to review your rights with your attorney today?
Yes.
Have you had enough time to talk to your lawyer about all of the charges and the facts and circumstances in today's case?
Yes.
Would you like more time to speak with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Attorney Wood, would you at this time waive a formal reading of the indictment for purposes of today's plea?
So waived.
And would you waive any and all defects in the indictment for purposes of today's plea as well?
So waived.
Ms. Barber, do you understand that the maximum and minimum sentence, minimum and maximum sentence for each charge to which you are pleading today are as follows? For aggravated assault, 1 to 20 years imprisonment. For aggravated battery, 1 to 20 years imprisonment. And for battery, 12 months imprisonment.
Yes.
And do you understand that today you are entering what's called a negotiated plea, which means that the state will recommend the following sentence to the court? That is 3 years credit for time served, with the balance of that probated, and to have no contact with the victim in this case, Mr. Keenan Gregory, and to stay away from the incident location, which I will read into the record once we conclude my portion of this.
I need you to state the sentence again because I didn't follow it.
Yes, Your Honor.
Not the conditions, but
3 years imprisonment, Your Honor, credit for time served thus far.
Wait,
Then the balance.
Probation.
there's no probation if the sentence is just 3 years in prison.
one moment, Judge.
3
3 to
years.
serve, 1 reduced to time served.
Ooh.
My apologies, Judge.
That's okay.
It's a phrasing issue.
It is a
An
phrasing
understanding
issue.
which is better. Your Honor, the sentence will be 3 years to serve 1, credit for time served, and the balance probated.
Okay. I follow that.
I think I might have missed a judge. So it's the 3 serve 1 commuted to time served, balance probated, and then I'll get all the numbers on the record at the end.
So that's not what Mr. Hand said. If that's what he meant, let's just get that clear. And so we can all use the right terms in here. I cannot commute a sentence. Only pardons and parole. Actually, only the governor can commute or the president. I can reduce something to time served. So if the vision is to have a sentence that says 3 years to serve 1, but the expectation is to have Ms. Barber get out in the next day or 2, then it would be 3 years to serve 1, reduced to time served. She can get out in the next few days. Balance probated, that would mean 2 years probation. If you wanted Ms. Barber to serve a year, she might get paroled, then it would be 3 to serve 1. And the credit for time served would get her what she's entitled to. If she's already been in for 4 months, she gets credit for those 4 months. The way you pronounced it was 3 serve 1, credit for time served. That's still 3 serve 1. It's just letting me know you think she should get credit. 3 serve 1, reduced to time served is you're going to get out in a few days and you'll have 2 years probation.
It's the first one, Your Honor. That I believe that was our intention, the first one.
The reduced to time served?
Correct.
Okay.
Because she's judge, and I'll get this on the record, but she's been in almost a year total.
Okay, great. I just need to know what people are recommending. In the end, I'll do what I think is right, but reduced to time served seems reasonable to me based on the very little I know right now.
Yes, Your Honor.
Okay.
All right. Let me make sure I know where I am. Okay. Let me restate that. It seems we had some confusion, so let me know if you don't understand it. Do you understand today that you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? That is 3 years to serve 1 year, reduced to time served for the amount of time you've already served, and then the balance of that will be probated on probation.
Yes.
Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you are pleading guilty today, the court also has the right to run those sentences consecutively, which means one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from our negotiated plea that you are expecting today, that you have the right to withdraw that plea of guilty?
Yes.
Okay. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you can not violate any criminal laws of any governmental unit, that being municipal, county, state, or federal?
Yes.
Do you understand that if you are placed on probation, you must follow all special conditions of that probation?
Yes.
Do you understand that if you fail to follow the special conditions of that probation, then you are subject to revocation of that probation for the balance of your probation?
Yes.
Do you understand that you are not allowed to possess or use a firearm while you're on probation?
Yes.
Are you a United States citizen, Ms. Barber?
Yes.
Do you understand that by pleading guilty to a felony, you also may not receive, possess, or transport a firearm in the future?
Yes.
And do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, which includes any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if you're convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes. Oh,
Can
no.
you repeat that question?
I'm sorry.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of aggravated assault, aggravated battery, and battery in indictment 22 SC 181087?
Guilty.
Is this plea freely and voluntarily given with the knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of this guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years from today to file this habeas corpus petition?
Yes.
And for a misdemeanor, you only have 12 months from today to file a habeas corpus petition?
Yes.
Okay. Your Honor, at this time, the state will give a factual basis for the plea today.
Okay.
If this proceeds to trial, Your Honor, the state would prove that on January 3rd, 2020, an officer was dispatched to a location regarding a physical dispute. Upon arrival, the officer spoke with Mr. Keenan Gregory, who advised that he had been bitten on his right hand, which had a small amount of blood that was observed by the officer. And he also advised that he had been bitten on his right leg near his knee, where the officer also observed a small bite mark from the physical altercation. Mr. Gregory advised that Ms. Tanja Barber was the person who bit him. They both reside in the house for different reasons. He's the houseman who takes care of the house. During this incident, Ms. Barber and him got over a dispute over the kitchen aisles. Maybe he was supposed to replace them or permit her to cook. She wanted to use them to cook. He did not do so.
The kitchen.
Aisles on the stove.
Oh.
The eye on the stove, I think.
I may be saying it incorrectly.
It's okay.
Okay.
And so there was a dispute over that, Your Honor, to permit her to use the stove. Mr. Gregory states that he lost his footing and fell due to her pushing him. And on his way down, she bit him in 2 places, one being his hand, the other being his leg. After the dispute, she left. He did not immediately go to the hospital. After calling the police, he made an appointment with the VA's office, the VA medical hospital. And there he received documentations upon discharge showing that his 5th metacarpal finger bone had been broken. So as a result of the incident, he broke a bone in his finger.
Because he fell or?
Because of the bite, Your Honor.
Oh,
So
okay.
when she bit him in the hand, she
Got
grabbed
it.
one of the fingers. And because of that, that's why I was charged as an aggravated battery.
Yep.
And that is the factual basis, Your Honor. The state would also note that as far as criminal history, we're showing 34 cycles and 3 convictions. And based on that history and the facts in this case, Your Honor, we think the recommendation should be accepted. Nothing further.
Okay. Ms. Tucson, do you have any open active cases for Ms. Barber?
No, Judge, there's nothing current for her. They're just
Okay.
very old, so there's no active probation.
Okay, thank you. Ms. Wood?
Thank you, Judge. Ms. Barber is 52 years old. She's a lifelong Georgia resident. She's lived here in Atlanta all her life. Her mom and her siblings live here, and she has an 11th grade education. She is telling me that she's able to return to her last place of employment, which is a barbecue restaurant. She works there as a server, also as a cook sometimes, Judge. She's also got a stable address to return, or not to return to, but to go to after she gets out. She has no issue staying away from the gentleman in the indictment. Judge, he was the overseer of the rooming home. They knew each other through an acquaintance. She's not planning to be in that area. She's going to stay with her mom when she gets out. I do want to note for the court, as Ms. Tucson said, the last felony conviction I see is from 2007. And I also want to get the dates that she served on the record. This case originally came in as a misdemeanor, so she was booked in under booking number 2100349. She served 264 days from January 10th, 2021 through September 30th, 2021. And then under her current booking number, she's been in since July 20th, 2022 until today. So that's 80 days for a total of 344 days, Judge, on this case. And Ms. Barber also wanted me to note for the court that she missed her April court date. And when she found out that she had missed it, she turned herself in. So we just ask that you accept the state's recommendation in this case, Judge.
The address that Ms. Barber should stay away from is 292 Old Jonesboro Road, Southwest in Atlanta. Is that correct?
Yes, Judge.
That's correct, Your Honor.
Okay, 2922 Old Jonesboro Road, Southwest in Atlanta. Ms. Barber, anything you want to add?
No, that's it, sir.
Pardon me?
That's it.
That's it. Okay. What's a kitchen? I'm not understanding what the fight was over.
Okay.
It's the stovetop, right?
Yeah,
The eye of the
iron.
stove.
Oh, the eye of the stove. Okay, as
Yeah.
in I want to put my pot on there because that's what the heat comes out of.
Yes, Judge.
Yeah.
The argument stemmed from
Yeah.
he alleged that she was burning everything that she cooked and setting the smoke alarms off.
Okay.
And there was an argument over that.
Got
The
it.
eyes needed to be replaced, etc.
Got it. Okay. And they are acquaintances. It wasn't a boyfriend, girlfriend thing. It was, Ms. Barber, live in this house that Mr. Gregory is somewhat responsible for.
Yeah.
Fix it guy, who knows what.
Yes, Judge.
Okay. All right. Ms. Barber, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Do you have any questions about any of the things the lawyers have been talking about?
No.
No? Okay, then I'll accept the plea. I'm sentencing you pursuant to the Probation Options Management Act, which means for the 2 years you're on probation, if you have a small violation, maybe you miss a meeting, you and probation will fix that.
Okay.
If it's bigger, you get arrested again and have a 35th cycle, that comes back to me. Okay? I will follow the recommendation, and let me get your counts here. On count 1, I will sentence you to 3 years to serve 1 year. That 1 year will be reduced to the time served, and the balance will be on probation. Count 2 is the same. 1 and 2, I don't think merge because the state has to prove something slightly different on count 1 about the relationship to Mr. Gregory, but they're close. Same sentence. Count 3 will be 12 months to serve. That'll run reduced to time served, and that'll run concurrently with 1 as well. So it all runs together to 3 years to serve 1 year. That 1 year is reduced to time served. And the balance is on probation. Special condition number 1, no contact with Mr. Gregory. He's not a stranger to you. Don't go find him. If you walk into a restaurant and he's already there, you walk out of the restaurant.
Okay.
You'll also stay away from that rooming house on 2922 Old Jonesboro Road. And finally, I'm gonna have you submit to a drug and alcohol abuse evaluation. And a professional is going to talk to you about that. And if that professional says, you know what, Ms. Barber would benefit from going to some classes or getting some treatment, that treatment will be part of your probation. Okay?
Okay.
All right. Anything else, Mr. Hand?
No, Your Honor.
Anything else, Ms. Wood?
No, Your Honor. Do I need to get reporting instructions?
We do. And I forgot one other thing. Ms. Barber, do you authorize me or my staff to sign the indictment for you indicating your guilty plea? We do it all electronically now.
Okay. So yes.
Yes. And Ms. Wood?
Yes, Judge.
And Mr. Hand?
Yes, sir.
Great. I got to go make a quick phone call. Don't leave because Ms. Tucson, who you will see on the screen in front of you, I'll make her big. She needs to give you a little bit of reporting instructions. Before we do that, the last defendant was Mr. Smith. Is that who they took away?
Well, they working back here now.
But is Mr. Smith the person they're working on?
No.
No. Okay. We don't need Mr. Smith yet. When we're done with Ms. Barber, though, the only person we have left is Mr. Smith. Okay, I'll be back out. Thank you.
It's on in College Park.
Okay, okay. Ms. Tucson, are you waiting for us?
I saw your email. What county will you be living in, Miss Barber?
It's Fulton. I just confirmed that.
Okay, so you'll need to report to probation in Fulton. Do you remember where that is?
901 or something like that.
No, it's 276 Memorial Drive. It's down the street. Have you been there before?
No.
Okay, I'm gonna write it down for her, Ms. Tucson.
Okay, and I will, I can also get the information. You have her address?
I'm gonna get that. Do you want me to email that to you?
That would be good.
Okay.
And then, let me grab the reporting date. October 25th.
At 8 or 8:30.
8 o'clock.
Okay. All right, we got it. Thank you.
And then I could write up those reporting instructions and give them to you for her, but October 25th at 8 a.m.
Okay, thank you, Ms.
And
Tucson.
then, if you could send me the address and just make sure on that day, Ms. Barber, you report for intake. They'll take your picture and get all your probation information. So you won't get a failure to report. Okay.
Okay. Thank you, Ms. Tucson.
Thank you.
This one. Yeah, this is. So, are you going back and kind of just for a brief second? Officer. Any officer back here? I got a key here. I gotta go down and okay. Can you put her back here? Put it in there. That's fine. Can I just put the address right now? Okay, you can. I'll be good. What's the numbers in front? Okay.
Yeah, I do. He said Smith, but there are like 3 Smiths on here. He didn't say the first name. James DeAndre. I think it's James. Yeah, I think that's number 3.
Who's Benson? Has he been seen?
Yes.
Yeah.
What did he
We didn't do a bond hearing for him. I think he, yeah, he just went on an inquiry calendar. Yeah.
So for the, what's his name? What's Benson's name?
Demetrius. Mhm.
Oh, thank you.
Mhm.
So it's 5 people in this book today?
There were multiple. There were like 13, maybe 2. He has 2 positions, the Benson versus about 12.
And they've been seen?
Yeah, the last one we have is This guy, number 3.
Oh, that was on Zoom.
Some were on Zoom, some were in person. I don't know how many were in custody versus on Zoom. I think so.
Extensively. So, Ms. Wood, yes, why would you want the credit for time served put on if it's reduced to time served? Just curious.
Oh, I guess that I just always want to be
You
like,
want it in the sentence? I mean, I.
just to be safe, just to be safe.
Okay, no problem.
Do you need those dates again?
No, I don't remember.
Okay, thank you.
Oh, yeah, I think it's a plea. It's not my client, so I don't. Yeah.
So how many inmates do we have with Gordon for inspection? How many inmates do we have with Gordon for inspection? It's going to be on this, Tonya, Barbara. I just got her. Okay, for her. We'll have to get it off the calendar. Because at first I thought we said 7. But when we went down, we only brought up 3. Right. Then they had to bring up the 1. So I think we had 2 women. It was 2 females. Who's the other female that's back there, you know? Barbara and. What's the name? Oh, Gordon. I think we had another female.
Oh, it might be one of Judge Lefter's, maybe?
Get all the names from her. She said it wasn't a female. It was only 1 female? That's all, yeah.
That's all we've seen.
So we only had how many today? 6? Well, 2 were sent back, right? Well, okay, 1, 2, 3. Compare these names. 4, 5. So that might make. He okay, 6. Still came and should have been, yeah. 6. So Hill is on that list? No. Okay. What is Hill name? So you have. Who was Hill? No, Hill didn't come. Hill never came. Are you sure? I thought Hill came up with Mr. Matt. No, we only had text. Because there was 2 back there when he was there. No, it wasn't. Y'all just brought up him by yourself? Okay, well, she might be right, because then I didn't count text. So text would have been 6. Okay, so text, so we should have 5. Okay, so you had DeAndre Smith. Yes. You had Tanya Barber. Yes. You had James Leroy Smith. Yes. You have. You have Benson. Yes. That was one. And you have Richardson. No, I don't have Richardson. Richardson, he might came. Oh, and then you have. No, Richardson was the one on Zoom, so we don't count him. No, Richardson was but you might not have brought him. I told you not to bring him. So text was the other. So you should have 5. I got 5. I went through. Did you put text in? Yeah, he's already on here. Okay, so we went through everybody. I did not have Richardson on here, but he come upstairs. I wasn't here. I was at home. So I don't think they have a 5 back there. Cause they ain't sent nobody back, so. Make sure everybody gets supposed to have came out. That's what I'm saying. Okay, just well, just so I make sure I wrote it down right, so we got a lot more.
Yes, ma'am.
The booking number credit was 2100249.
349.
349.
Yes.
From January 10th.
2021.
You said 349. Wait, 349.
Yes.
Okay. January 10th, 21.
Yes.
Through September 30th, 21.
Yes, ma'am.
There's
only 5. James Smith is still back there.
Okay, I got, yeah, he
From
was
7 he's gonna be coming out. That's all right.
22 to present.
Yes, ma'am. Thank you so much.
No, Richardson was an attorney.
But Mrs. Smith, it was another Mrs. Smith, he was on Zoom.
Yes.
That's the one with the.
That was,
We had two Smiths back there, but we
Yeah.
had a Smith on Zoom too.
So we
had three Smith?
Yes.
I don't put him over here because he wasn't in custody.
Yes, that's Smith that was on Zoom.
Right. And Mr. Benson is the one that had the seizure.
Poor thing. Is it gonna be okay?
Well, they Grady just.
We ready for Smith?
I think this is. Sorry, I
All right. Thanks for everyone's patience on Friday afternoon. Everything okay back there now?
I'm not sure.
They're not letting you back there?
I don't know, yeah, I'm ready to the.
Okay.
Ms. Rivers, you good?
Yes, Judge, I'm here.
All right. This is position 3 on our calendar. Last one for the day, I think. It's State versus James Leroy Smith. Is that you, sir?
Yeah, sorry, that was me.
Great. I'm Judge McBurney, and we need Mr. Whitenauer. Are you still with us, Mr. Whitenauer?
Yes, Judge.
There he is. Let us put the spotlight on him. Great. Mr. Smith, Ms. Wood tells me you are prepared to enter a plea in your case. Is that correct?
Yes, sir, I am.
Okay. Mr. Whitenauer, who's the prosecutor, is going to put you under oath in just a moment. Once you're under oath, please answer all his questions and mine truthfully and completely. And if you've got any questions at any time because you can't hear what someone said or what was said confuses you, make sure you let Ms. Wood or me know, okay?
Yes, sir.
Mr. Whitenauer, when you're ready.
Yes, Judge. Just make sure that I don't have the same problems we have had in the past with my microphone. All right. Sir, can you hear and see me?
Yes, sir, I can.
All right, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give and the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. I'm going to ask you a couple questions. If you'll please respond out loud, yes or no, so that the court reporter can take down everything that we say. Agreed?
Yes, sir.
All right, please state your name and spell your name.
James Leroy Smith Jr., James Smith.
All right, and please state your date of birth and how old you are.
2393, 29 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, sir.
How far did you go in school?
11th grade.
Can you read and write in the English language?
Yes, I can, sir.
Have you had the opportunity to review the document that charges you in this case, that is the indictment?
Yes, sir.
Do you fully understand the nature of the charge pending against you?
Yes, sir.
By pleading guilty today, you were giving up certain rights. I'm going to read those rights to you, and after each one, if you please acknowledge that you understand that you were giving up that right by entering a plea today. So, you were giving up the right to a trial by jury. Do you understand?
Yes, sir, I do.
The right to be presumed innocent.
Yes.
The right to confront any witnesses who may testify against you.
Yes, sir.
The right to subpoena any witnesses for your defense.
Yes.
The right to testify yourself and to offer any other evidence in your defense.
Yes, sir.
The right to have an attorney to assist you throughout the trial proceeding.
Yes, sir.
The right to not incriminate yourself.
Yes, sir.
Do you understand that by entering a guilty plea, you are waiving or giving up all of those rights?
Yes, sir.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by a jury?
I understand, sir.
You are entering a plea today to the one count of terroristic threats, family violence. You need to understand that charge carries a sentencing range of 1 to 5 years in confinement. Do you understand?
Yes, sir.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Probation and Cobb.
Do you understand that by pleading guilty today, that your probation or parole will almost certainly be revoked?
Yes, sir.
Okay. Understanding that, do you wish to proceed with this guilty plea today?
Yes, sir.
Do you understand that this is a negotiated plea?
Yes, sir.
Do you understand that your attorney and I have discussed the case and that we have agreed that the state will recommend to the court that you be sentenced to 5 years, serve 180 days, that you be given credit for any time that you have served so far. The balance will be served on probation with special conditions to include a mental health evaluation and any treatment as recommended, that you attend and complete the family violence intervention program, that you consume no drugs or alcohol, and you subject yourself to random screens, and that you have no contact with the victim or the minor child until further order of the court. That you, excuse me, and did you say that you had graduated high school?
No, sir.
You obtain your GED, that you maintain gainful employment, and finally, that you possess no weapons. Do you understand that's going to be the recommendation to the court?
Yes, sir.
Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which for this one count is 5 years in confinement?
Yes, sir.
And Your Honor, please correct me if I'm wrong, but if you do not like the sentence that the judge is going to impose, you may withdraw your plea.
That's correct. So if, just as an example, Mr. Smith, I hear more about your case and I say, you know what, it's 5 to serve 2 years. You and Ms. Wood can confer and you may say, I agreed 6 months, not 2 years. So no, thank you. You can withdraw your plea, no questions asked. Okay.
Yes, sir.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. There are also special conditions that I stated previously. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, sir.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, sir.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, sir.
Are you satisfied with what your lawyer has done for you in this case?
Yes, sir.
Do you have any more questions for your lawyer before we go on?
No, sir.
Okay, so you hesitated there, and I want to make sure that you do not want any more time to speak with your attorney about this case before proceeding.
No, everything's good, sir.
Okay. Have you understood everything I've asked you so far?
I did, sir.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes, sir.
How do you plead?
I plead guilty, sir.
Is your decision to plead guilty made freely and voluntarily?
Yes, sir.
Are you a United States citizen?
Yes, I am, sir.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file a direct appeal. The second way is a habeas corpus petition, and for this one count, a felony, you have 4 years from today to file a habeas corpus petition. Do you understand those time limits?
Yes, sir.
And sir, are you asking to be sentenced as a first offender?
Yes, sir, I am.
Okay. You need to understand that there are some benefits and risks to requesting to be sentenced as a first offender. The benefits are that if you do what the court orders you to do and do not violate the terms and conditions of your probation, you will not have a conviction for these offenses. The risks are that if you violate the sentence or your probation, commit a new offense, etc., we will ask that you be brought into the court and ask that you be adjudicated guilty, meaning you will have a conviction, and then the court can re-sentence you up to the maximum sentence we discussed earlier, which is 5 years in confinement. You understand?
Yes, sir.
Understanding this, do you still want to be treated as a first offender?
Yes, sir.
And have you ever been convicted of a felony before?
No, sir, I have not.
Okay. And have you ever used first offender in any other case and in any other place?
No, sir.
Okay.
So I'm confused. You're on probation in Cobb for a misdemeanor?
Yes, sir.
Okay. I'm not confused anymore.
Okay, I want to make sure that you don't have a felony conviction, because I thought, and Ms. Wood, please correct me if you have a different understanding, because in looking back, I do see a November 28, 2016 burglary out of Cobb.
I think that was reduced as part
Okay.
of the plea negotiation for that case.
Okay,
I believe it was a criminal trespass, but I also could be wrong.
Well, let's find out from Ms. Tucson. Ms. Tucson, you still with us?
I am. I was in the copy room. Which Smith?
Welcome back from the copy room.
Right.
We have James Leroy Smith. It's position 3 on the calendar. And the question is whether you've got any evidence of felony convictions, felony probation here in Georgia.
Okay, I don't believe so. I'm going to double check.
I am looking at that GCIC judge, and upon further review, I do see that he was sentenced to 12 months of probation. So that is suggestive of a misdemeanor resolution.
Yep. Okay.
I don't see he now. I double checked, not for felony.
Okay.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about July 13th of 2021, officers with the Alpharetta Police Department responded to 1308 Jefferson Court, which is located in Fulton County, and spoke with the victim, in this case, Shamiracle Lewis. That's SHEMIRACLE, Lewis, common spelling. She showed officers Instagram messages, which showed several messages from her ex-boyfriend, the defendant, James Smith. In those messages, Ms. Lewis had requested that he stop talking to her, but he continued to send messages like the following: "Killing you would be too easy. You will not feel what I feel. I promise I'm going to make you feel it. I just don't want to tell you how you will, but you wouldn't know it's already the end for me, since nobody understands my pain. I already feel like I don't have nothing to lose. At least if I get caught, I will have a free meal for the rest of my life and a bed and no rent." He also made comments about having their 2-month-old child sleep with their grandmother because Mr. Smith was going to come after the victim first. He also implied in some of the messages that he had been at her apartment watching her and that he would be coming to her apartment with others. The messages began on July 12th and continued until July 13th when officers arrived. Your Honor, this sort of communication is consistent with the defendant's criminal history. Although he does not have a felony conviction, I do think it's important that the court be aware of the several misdemeanor convictions of violence. In 2012, a simple battery out of Cobb. 2012, another simple battery, simple assault, and disorderly conduct out of Cobb. In 2013, a simple battery and obstruction of or hindering a 911 call out of Cobb. Again, in 2013, a battery, family violence, and cruelty in the 3rd degree out of Cobb. In 2016, a simple battery conviction out of Cobb. Again, in 2016, there's that burglary arrest, which was resolved, I guess, as a criminal trespass out of Cobb. In 2018, theft by taking, obstruction, and possession of less than 1 ounce of marijuana out of Cobb. He entered a no contest plea to those charges. In 2019, a simple battery and obstruction out of Cobb. And then we have this case, Your Honor. So there is, from the state's perspective, a consistent pattern of violent behavior. And in this case, that violence was redacted into or taken down into words and directed at the victim. And that's why we're asking for this mental health evaluation. And of course, the Family Violence Intervention Program, and asking also that he be under supervision for 5 years so that should this behavior continue, he can be brought back before the court and dealt with accordingly. Nothing further for the state.
Okay, so he'll be under supervision for 4.5 years, but that's just how we structure it. I don't know if you had the time or the ability to dig into, there was so many simple battery convictions. I'm curious if they all involve Ms. Lewis or if Mr. Smith is just getting into it with everyone he knows.
And I'm sorry, Judge, I've not had the opportunity to look at further into those getting certified or just even copies of those convictions.
That's okay. I didn't think you would. I don't mean that in a negative way. I just wasn't sure if there was a way, systems are getting more complete, that online you could see, oh, look, this is the same victim again and again. All right. Well, Ms. Wood's going to be able to answer some of that. Ms. Wood, your turn.
Thank you, Judge. And to pick up from there, it's my understanding they did not involve Ms. Lewis. Judge, Mr. Smith is 29 years old. He's originally from Chicago. He's lived here in Georgia the past 12 years. He currently resides in Cobb County. He has 3 children ranging in age from 1 to 10. I don't know if Mr. Whitenauer mentioned it. Miss Lewis and that child actually live in Texas now.
He did not. That's good.
I want to just let the court know Mr. Smith and Miss Lewis go through a third party for childcare stuff. So we don't have an issue with staying away from her, obviously, but I wanted to make sure it was included somehow in the structure of the sentence because he obviously wants to have a role in his child's life. So if it could be no violent contact or the third party could be worked in there somehow, that is our request for that matter. Judge, he has a job that he can return to. It's a car detailing shop in Mapleton. He's eager to get back to work. Let's see, days in custody.
Before we do that,
Okay.
you mentioned Mr. Smith has 3 kids.
Yes.
In addition to the 1 kid in Texas, or one of his 3 kids is the child with Ms. Lewis who is in Texas?
One is with her and then he has 2 other children.
Okay, and those 2 are local?
Correct?
Yes.
Yes.
Okay. All right, days in custody.
Okay, Judge, he's got a total of 138 days on this case. He served 25 days from July 25th, 2021 to August 14th, 2021. And then 113 days from June 17th, 2022 to the present date. And Judge, he did ask that I let the court know he missed his arraignment date in May and he was in custody in Cobb County for that probation. So he just wanted to let the court know that he was not being disrespectful to the court.
Okay.
And that is why he missed that court date. Judge, we just ask that you give him credit for the time he has served, that you accept the state's recommendation and sentence him under first offender.
Tell me, Mr. Smith, why you think first offender is a good idea for you. I think you understand how it works. It's not a felony conviction, which is helpful for getting a job, that kind of thing. But it has a risk because if while you're on probation, anything like what happened with Ms. Smith comes up again, you get arrested again for simple battery. I don't know who these people are who you're hitting. But if something like that happens, that's a reason for me not just to revoke your probation, but to take away your first offender status and then resentence you, which I can. I can't sentence you to more than 5 years. That's the maximum on this. But without a trial, I could say, gosh, we all misunderstood your situation. Here you are 6 months into your sentence, meaning after you get out, and you just got arrested for punching this guy in the nose or pushing this girlfriend over. I'm going to revoke a bunch of your time, but I'll probably take away your first offender. So it seems kind of risky, just given your pattern of arrests. So tell me why you think, why you want first offender.
I understand how you feel about that.
It's not how I feel.
I understand, but I honestly, I've been trying to do right. Like, you know, me and Miracle, we had our issues, but we went past that. Although they live in Texas, I've been trying to get on the right path, you know, and I've been trying to stay focused on working and, you know, trying to get my education and everything. So I really feel like it could motivate me to keep me out of trouble.
Well, that's a reason to do it, as long as you understand the consequence that if while you're on first offender probation, I find that you have meaningfully violated probation, and you get a hearing and Ms. Wood would represent you and all that. But if I found you violated it, if I take away your first offender status, I resentence you for this case, and it won't be 5 years to serve 6 months balance probated. It'll be a bunch of time in because you will have shown us this, you're not able to get on that right path.
I
As long as you understand that, you're eligible for it, and I will sentence you as a first offender. Is that what you want?
Yes, sir.
Okay. Well, Mr. Smith, I find there's a factual basis for your plea and that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which means if while you're on probation, you have a minor violation, let's say you miss one of these family violence intervention program classes, you in probation can work through that. But if it's more serious, you get arrested again, you just completely blow off one of these requirements, that comes back to me and we'll figure out what we do from there.
I understand.
I will sentence you as a first offender. I find that you understand the risks and benefits of that. I will follow the joint recommendation, and on the only count of the indictment, I will sentence you to 5 years to serve 6 months. You'll get credit for the time you have served. The balance will be probated, so that's 4.5 years of probation. Special condition number 1 is that you will complete a family violence intervention program. And hopefully Ms. Wood explained to you, that's not one class. It is a series of, it's one each week, but you actually go for several weeks. It's not a one and done. You will need to submit to a mental health evaluation. I don't mean to suggest I have any concerns about your mental health. To Mr. Whitenauer's point, just looking at how some of these things have played out, someone should talk to you about mental health and whether you would benefit from any treatment, whether that's counseling or medication or maybe nothing, but I'll have an expert determine that. You'll be subject to random drug and alcohol screens for the first year of your probation. If that first year, negative, negative, negative all the way through, we'll stop doing the random drug and alcohol screens. You'll have at least 2 a month of those. And you can have no direct contact with Ms. Lewis. You can work through a third party. You can't call her up directly. Who is the third party? Is it a friend? Is it a relative?
Her grandma.
Okay. You're welcome
Her
to.
mother.
Pardon me?
Her mother.
Her mother,
Yes.
your child's grandmother.
Yes.
So as long as Ms. Lewis's mother doesn't mind you contacting Ms. Lewis's mother, you're free to do that to arrange access to the child. But you cannot do that directly through Ms. Lewis.
Okay.
So no direct contact with Ms. Lewis. And you'll need to get your GED. You don't need to get that right away, but if you made it through 11th, you were almost there. So get your GED and that'll get you your high school equivalency. Mr. Smith, do you authorize me or my staff to electronically sign your indictment indicating your guilty plea?
Yes, sir, I do.
Ms. Wood
Yes, Judge.
and Mr. Whitenauer.
Yes, Judge.
All right. That leaves, I think, only Ms. Tucson, who is with felony probation, talking with you, Mr. Smith, about how you're going to need to report and where you report. Okay?
Yes.
All right. Ms. Tucson, when you're ready. Do you know this Mr. Moore on the screen? He's been on the whole time.
Really?
Yeah.
That might be my client that I waived.
Oh my gosh, I feel terrible for him because he finally saw his face. He's been listening. Is that Derek Moore?
Him, Judge.
Oh.
Oh, no.
Hey, Derek Moore, you just lost 3 years of your life. You're never going to get back. Sorry about that. Ms. Wood waived arraignment for you. You're going to get a scheduling order. And you just need to make sure you keep her posted. If your phone, email, hashtag, say so more changes, okay? Excellent. You're free to go. Ms. Tucson, when you are ready.
Okay. Mr. Smith, what county do you live in?
Cobb.
Okay. Do you have a phone number?
Yes, 470 451 6099.
Okay, do you know where probation is in Cobb County?
Yes, I do.
Let's make sure he does, because he's been on misdemeanor probation, and I don't know how Cobb works, if that's the same facility or a different one.
I believe it's probably different if it's not felony. And Miss Wood, can I also send you this?
Yes, please.
Okay, Mr. Smith, it is 590 Commerce Park Drive in Marietta, Georgia, 30060.
All right.
I'm writing it down for you.
Okay.
And we will transfer your case there, so you'll want to report October 25th.
Okay.
at 8 a.m. Failure to report will result in a warrant. And do you have your address offhand?
Yes, 2116 Valley Oaks Drive.
2116.
Yeah, Valley Oaks Drive, Smyrna, Georgia, 30080.
30080. Valley Oaks Drive. Is there a unit number or that's just?
That's a direct address.
Okay. All right. Thank you.
I think that's it. Mr. Whitenauer, anything else from the state?
Nothing from the state.
All right, Ms. Wood, anything else?
No, Your Honor.
Thank you, everyone. Have a wonderful weekend. Appreciate your time this Friday.
Thank you, Judge.
All right, bye.
Here, I take that. All right. Do you have the indictment I gave you?
Bye, Ms. Rivers.